Furthermore, the claimant has deposed in her statement that the deceased soon after coming from his duty suffered heart attack, due to which he was admitted in the hospital. As regards the judgment cited by learned counsel for the appellant, the ratio of judgment is not applicable on the peculiar facts and evidence led by the parties. In the light of aforesaid, this court is of the considered opinion that the deceased suffered heart attack due to stress and strain of his job, and his death arose out of the employment. As such, the Learned Workmen's Compensation Commissioner is justified in awarding compensation to the claimant. Learned counsel for the appellant would submit that the Learned Workmen's Compensation Commissioner has erred in law by awarding compensation in favor of the claimant for the reason that, firstly, death had not been occasioned during and in the course of employment; secondly, there is no nexus between the death and the employment; and thirdly, there is no iota of evidence on record so as to show that the work which the deceased was doing, that is, driving, contributed to his death. The clear position, therefore, is that any judicial magistrate, before taking cognizance of the offence, can order investigation under Section 153 (3) of the Code. If he does so, he is not to examine the complainant on oath because he was not taking cognizance of any offence therein. For the purpose of enabling the police to start investigation, it is open to the magistrate to direct the police to register an FIR. There is nothing illegal in doing so. After all, registration of an FIR involves only the process of entering the substance of the information relating to the commission of the cognizable offence in a book kept by the officer in charge of the police station as indicated in Section 154 of the Code. Even if a magistrate does not say in so many words while directing investigation under Section 156 (3) of the Code that an FIR should be registered, it is the duty of the officer in charge of the police station to register the FIR regarding the cognizable offence disclosed by the complainant, because that police officer could take further steps contemplated in Chapter 12 of the Code only thereafter. When a magistrate receives a complaint, he is not bound to take cognizance if the facts alleged in the complaint disclose the commission of an offence. The magistrate has discretion in the matter. If on a reading of the complaint, he finds that the allegations therein disclose a cognizable offence and the forwarding of the complaint to the police for investigation under Section 156 (3) will be conducive to justice and save the valuable time of the magistrate from being wasted in inquiring into a matter which was primarily the duty of the police to investigate. He will be justified in adopting that course as an alternative to taking cognizance of the offence itself. Learned counsel has also argued that the notice under Section 17 (3) of the Huda Act was never received by the plaintiffs. Therefore, the subsequent proceedings under sections 17 within bracket 4 and section 18 of the Huda Act are totally violative of the procedure prescribed by the Act. Regarding the judgment relied upon by learned counsel for the appellants, the learned counsel for the plaintiffs oblique respondents has submitted that the same is not applicable in the facts of the present case because in that case the procedure under the Act was followed by the authorities, and in that case the plaintiffs had not paid any substantial amount after the payment of the initial amount pursuant to the notices issued by the defendants.